So before we get into the material, I want to share a video with you from the Religious Freedom Institute, where I serve as Vice President for Public Policy. And so I'm going to sit down, let you watch a short video, then we'll come back and roll up our sleeves and get to work. Religious freedom is a core human right that contributes to other societal goods. Tomorrow's leaders need to understand the essential and critical role that religious freedom plays in society.
I was raised in a foster home, and I always heard that through the welfare system that people get paid for taking care of you, and I always wondered whether they love me or not. You know, I needed to know, what is my purpose? What is my peace? And it's through God that I was able to find out where my place, where I stand as a person.
I think it can be really hard in school to orient yourself towards a goal and a purpose. But it made me realize that God and the chance to live out your faith and seek your faith is everywhere. And I find that when I do remember that it is, all of the anxiety about the future and where I'll be after I graduate diminishes a lot.
There had been a murder in a field in Southeast Washington, D.C. 9 young people had been shot and 4 of them had died. It was really tragic, but at that time, I was literally prompted by the Holy Spirit to start preaching there. And people began to come to Christ, and we actually ended up building a church. Project Eden came out of a vision that God had given me for an urban agricultural initiative or an urban garden. We've hired over 100 young people, and we do offer the food in the garden free of charge.
I think that the religious perspective, it shapes everything I do, because I think about my activities, my endeavors in terms of what I can do with the gifts He has given me. You know, now, unlike the way I grew up, Jews are less safe, even in America, than they were just a few short years ago. It's really important for us to take note of a turning against the Jews insofar as it represents not just a turning against Jews, but a turning against religion and against religious freedom.
I think religious freedom in America is under threat from the rise of secularism. Unfortunately, in our contemporary culture, many people want religion out of our public discourse.
There's been an increasing climate of silencing believers, silencing those whose views are not palatable to the popular culture.
We have an amnesia that has crept into many of our institutions, where there's this sense that, well, maybe religious freedom is just a subset of freedom of expression or freedom of association. And it's something that we can more or less dispense with.
Some of the things I worry about are healthcare, where people of faith should be free to follow their conscience. Another area that I have great concerns about is education. What we're seeing, particularly with the advance of gender ideology, is that the state is more than proposing, it's imposing.
The growth in anti-Semitic attacks, in anti-Semitic rhetoric that we're seeing is very grave.
Religious freedom is a crisis in the United States because we know historically that violent religious persecution occurs around the world and is preceded by invidious discrimination. And that's what's occurring in the United States against many religious communities.
We need to recognize that our human dignity is bound up with this desire to live out our most deeply held beliefs, not just for ourselves, but for the life of the world, for the life of our communities.
Faith is not just an individual thing. You know, we come together as believers and we create institutions. We have churches, but believers get together and they do something together. They create schools, they create hospitals, they create businesses that run according to their religious principles. And that's a gift for society.
The American genius has always been to bring religion into our public lives. We're in danger of losing that. RFI wants to recover the meaning and value of religious freedom in our country, which we fear is being lost amid some of the fierce battles that we're undergoing now.
The Medical Conscience Rights Initiative is a multi-year, multi-state project to protect the religious conscience of healthcare workers and healthcare institutions.
We are actually promoting a new initiative called the Brethren in the Faith Initiative, in which we hope to work with Christian leaders in particular to become champions in the fight against anti-Semitism.
Religious freedom is being ripped out of our classrooms. No one's teaching it. Our youth aren't learning about it. And so America's First Freedom curriculum was written to fill that gap.
RFI works all over the world. But in order to do that, the United States has got to protect religious freedom here at home. If we lose free exercise equality, not only will our beloved country suffer, but the entire world will suffer. At RFI, our mission to advance religious freedom for everyone, everywhere, must begin at home.
Well, that tells you a little bit about the Religious Freedom Institute, our mission and our work, and really how it's easy for us to collaborate with you on protecting religious freedom. We want to look together a little more academically, with a little more rigor, classroom rigor, at the threats to religious freedom that we face today. Many of those come in an ideological form. They come in the form of thoughts and ideas that, while raising to a higher level in society, have the effect of repressing religion and religious freedom at home, for you here in Poland, perhaps, or certainly threaten that in the future. And these are threats that we certainly see in America. Do they relate to religious persecution around the world? Absolutely they do. Absolutely. So I hope we'll have some time to talk about that and understand how that's certainly true. So let's begin this morning. We're going to be looking at emerging legal and cultural threats to religious freedom from the American experience. We'll step in, I hope, and have some conversation about the things you're facing here. I think that we face many of the same things, but I don't want to be much of a prognosticator, but I do think that many of the things that we are facing now, you're beginning to see, and they may escalate here and throughout Europe. So I understand that this is part of a larger theme, which we're very glad to be part of talking about and discussing with you, counteracting violations of the freedom of conscience and religion, including interference by public authorities in revealing one's worldwide and religious convictions or beliefs. So this morning we'll really kind of land right there. So follow with me. I want to leave you with a beginning thought, because you're in an institute of education. And that thought is that if religious freedom is to be restored to its proper place in American society, and if it's to be preserved or restored to its proper place in your society, then the gateway for that is education. Other than the family, no sector is more critical to shaping our culture than the public and private institutions that educate our children and our future leaders. To take that just a step further, I want you to understand that education is the incubator of culture. As I'm going to say, many of the most serious threats, strongest threats to religious freedom that are percolating today are cultural. And so I want you to understand that here, the enterprise that you're part of stands in a very unique space to address these threats. Well, yes, there are movies and there are other influences, certainly in society, that shape culture, but education has an opportunity to impact children at all ages and to our next generation of leaders that no other institution really has in society. And so I speak of education as the incubator of culture, and it is the foundation of strong advocacy. You know, it's an interesting thing about in Washington, D.C., and in working with our various state governments, that as a nonprofit institution, you can't go in and persuade or what we call lobby. You're simply prohibited from doing that. We do education. Education is the strongest form of advocacy. That's how we do our policy work. If you can do research and you can gather empirical data and you can establish principled understandings and reasons for why religion is critical to society and the role that it plays in benefiting everyone in society, that is the strongest form of advocacy. So I want to leave you with that this morning because it's very important for you to know you're part of that enterprise. So, key legal and cultural threats to religious freedom. Let me list a few of those, and then we'll come back and work through them. First, a new understanding of the human person and conscience. So let me just kind of list these, then we're going to come back and reflect upon them. And then hopefully later we'll talk about them. Second, legal decisions involving religious freedom that come up short. They give us a glimmer of hope, but they come up short. They may be resolved on a technicality rather than an affirmation of religious freedom. Third, legislative initiatives shaped by cultural influences and rooted in a false anthropology. Now, you're going to hear me today and tomorrow talk a lot about how politics and culture sit, or politics and law sit downstream from culture. So what you see, and I don't think this is unique to the United States, but you certainly see it there, is that many times our legislation that we see coming out of Washington is in fact shaped by cultural influences. And it is not itself shaping culture, but culture is shaping what's in our legislation. Fourth, legislative initiatives that repress religious freedom and create a new moral orthodoxy. And finally, legislative initiatives that abolish defenses of religious freedom under RFRA. This is our Religious Freedom Restoration Act that was passed in 1993. You don't need to worry about that right now. Just know that there are legislative initiatives that abolish defenses of religious freedom. So what we're going to do this morning is we're going to look at number one very briefly. We're going to look at number two and examine that. And then I'm going to deal with 3, 4, and 5 together. So that's how we're going to approach this. So first, let's pause here for just a moment. One of the most serious threats I think we face today is a new understanding of the human person and conscience. I think what we see today is a struggle to define reality. Individuals are struggling with who they are, the very basic questions of life and meaning of life here. We see a struggle to define reality. In essence, a conflict between two competing accounts of reality. A reality in which God is relevant, religious truth is relevant, and it shapes our understanding of reality over against a reality in which God is no longer relevant or not as relevant as he was. And religious truth is considered kind of passé. It's kind of, that's what other generations used to believe, but how does it apply today? Those two competing accounts of reality, where in the second, the dogma of the self, kind of a radical understanding of the human person, shapes that new reality. And so I think what we're seeing today in culture is not just conversation about the importance of the self, but the elevation of the self to a newer level of self-understanding, a self-actualization that in fact is not healthy. I call it a supra-individualism, a sort of self-apotheosis where individuals today become so centered on their own abilities, their own thinking, their own sense of trying to understand who they are and what life is all about, that they find all of the answers to that and all of the truth for that in themselves. And this is challenging because those questions are indeed difficult. But in this new heightened sense of self-actualization, this supra-individualism, it's a new level of self-affirming truth that seems to shutter an understanding of human dignity. And it allows the human person to make critical decisions on their own about the meaning of life, the limits of life, the roles of marriage and family in society, and the very nature of the human person. This is the path of culture today. And it's a conversation we must have. And I think we must deal with those issues and those questions that we are faced with. But not only this new understanding of the human person, but also conscience. I've reflected on this even more recently as we do some work, as you saw in the film alluded to our work in medical conscience and our effort to understand conscience. And That's not easy. But I turned to an expert, Dr. Budziszewski at the University of Texas, and I quote, "Conscience is a privilege of rational beings, an awareness of real moral law." That there is a real moral law outside of me, that there is actually a real moral law. He goes on to say, and I quote, "Even though it is my conscience that commands me to act and accuses me when I do wrong, it seems to speak to me with an authority greater than my own." And so you begin to understand this relationship between the new understanding of the human person and how that stands in conflict with conscience. So what I'm seeing today is really a very subtle redefining of conscience. Not directly affirmed, but it is in fact, I think, what is happening. He goes on to say, if science means following the evidence wherever it leads, then the most scientific explanation of conscience is that it really is what it presents itself to us as being, an interior witness to moral truth that we did not make up for ourselves. So I think getting to the root of the conversation today, these are the things we must look at that really form the foundation to some of the cultural threats to religion and religious freedom. Second, legal decisions involving religious freedom that just come up short. First, Our Lady of Guadalupe School versus Morrissey Berry was consolidated with another similar case, and the cases involved employment discrimination suits filed by teachers at two Catholic schools in the city of Los Angeles. So very quickly, as we listen to the facts and then we look at the analysis to understand why the decision comes up short. In Our Lady of Guadalupe, a teacher was terminated because she failed to integrate a new advanced reading program into her classroom instruction. She filed a lawsuit in federal court in the U.S. claiming that she was fired because of her age. She taught for years. She was accused of not introducing this new advanced reading problem, and she said, well, what really is the problem here is that you just don't like the fact that I'm older. It was not the case, but she filed suit under the Age Discrimination and Employment Act of 1967. And the consolidated case, I mention that because the issue is very similar. A teacher in a Catholic school, again, she was on many occasions observed that she just could not control her classroom. She'd been ill for some time. She wanted to say that it was because of her protracted illness that she just wasn't able to do that. But the school said, in fact, this has been something that has been ongoing and is a problem. And so she was terminated. The U.S. Supreme Court reached a 7-2 decision in favor of the Catholic schools in both of those cases. And the court hearkened back to preceding decision in Hosanna Tabor case of 2012, in which they applied what they called the ministerial exception. So follow with me here. You can track this. You don't need a law degree to do this. That's the thing about law. You know, we go and spend a lot of money getting law degrees, but sometimes it's just pretty simple. So follow with me for just a moment. So in writing the decision for the Hosanna Tabor case, which would be applied in the two cases that we're looking at today, Chief Justice John Roberts stated, requiring a church to accept or retain an unwanted minister or punishing a church for failing to do so intrudes upon more than a mere employment decision. Such action interferes with the internal governances of the church, depriving the church of control over the selection of those who will personify its belief. So, at the end of the day, in this court, the court saw no place for the federal government to interfere. And according to Justice Alito, who wrote the opinion in the Our Lady of Guadalupe case, when a faith-based school entrusts a teacher with the task of educating students in matters of faith, judicial review of the employment practices of the school undermines the school's independence in a way that the First Amendment of the U.S. Constitution does not allow. So, you say, well, David, that was a reasonable outcome. And in fact, it was. It supported the right of the school to make its own determination in matters of hiring as it relates to people who exercise roles that are faith-related. So you say, David, how does that come up short? How does the court not quite get to the point that maybe they should have? Well, we celebrate the decision, but we do it with caution. The opinion stops short of applying the ministerial exception to all positions at a religious school when the decision stated this: a teacher, such as an instructor in a class of world religions, who merely provides a description of the beliefs and practices of a religion without making any effort to inculcate those beliefs, could not qualify for the exemption. In other words, the court was saying, well, this exception that allows the school to practice and uphold its religious faith applies to this teacher and to this teacher, both in both of these cases, but it may not apply to another teacher. It may not apply to other employees that work within the mission of the school. So the weakness of this ruling is really very clear. It leaves open the possibility, perhaps even invites cases in which the Supreme Court may choose to limit the ministerial exception by applying it only to those employees who impart formal religious teaching. But in fact, when you think about religious schools, and by extension, even other faith-based institutions, every employee is important to the mission of that school or faith-based institution. Every employee is trusted with representing the core values of the institution and representing the religious principles that animate that institution. It's not to say that employment decisions made by religious institutions are inviolable, but we need to be clear that America's founders, as we understand the First Amendment and the Constitution, did not rest America's first freedom on the tenuous nature of a single exemption. This is where the court comes us short. That the decision reminds us that when we begin to understand religious freedom as one or a cluster of exemptions, we are moving away from understanding religious freedom and the role that it plays in society as the founders envisioned. Let's go to a second case, one that I didn't mention in my address on Thursday. Let's look for a moment very quickly at the Fulton versus Philadelphia case. It's a dispute in which the city of Philadelphia refused to continue contracting with a Catholic foster care agency, Child Care Social Services, operating within the city of Philadelphia for 50 years. 50 years. But the city now refused to continue contracting with the Catholic Social Services because the agency refused to place children with same-sex families. The holding, the decision by the court, which was unanimous, 9-0. The court held that the city's refusal to contract with Catholic Social Services unless the agency agrees to certify same-sex couples as foster parents violates the free exercise clause of the First Amendment. Now, what's good about this decision? There's some fantastic things about this decision. One, that it was unanimous, which is seldom the case with the U.S. Supreme Court. So it was a unanimous decision. Second, the court respected the historical pattern of service and faithfulness of child social services, of Catholic social services, to its beliefs. It was really interesting. When you read this decision, the court based part of its reasoning on the fact that Catholic social services had been faithful to their mission for so long. 50 years they'd been doing this. And for 50 years, they weren't granting foster care privileges. They weren't certifying couples of same-sex marriages for 50 years. But they'd been faithful to their mission, and the court even recognized not just has Catholic Social Services been faithful to its mission for 50 years, the court says, and the Catholic Church has been faithful to that mission for 200 years. So there is something to be said about being faithful to our mission. And this was recognized even in the High Court in America. These are good things about that opinion. And the ruling, of course, was good. Well, David, why did that decision come up short? Well, because it really turned on a technicality. So they acknowledge the mission, the integrity of the mission, but at the end of the day, the court's decision turned on to technicality. The fact that the city's own contract with Catholic Social Services and with other foster care agencies, the city's own contract had an exception clause that allowed the city to grant an exception. So here, after 50 years, the city comes in and wants to kind of change the rules. We've had an exception in our contract. We still have the same exception that would allow you not to certify a same-sex marriage. Now we want to change the rules a little bit, and even though that exception is still in there, we want to say it doesn't apply. So the court's decision turns on this little technicality. It's not an overwhelming decision in favor of religious freedom. The court stepped back into a little safer territory and said, well, you really have an exception in your contract that you've honored, you should continue to honor. So it comes up short. Otherwise, the city would have likely won, because the non-discrimination clause in the contract, listen to this carefully now, because this is where we get in the weeds a little bit today. Without that technicality, the city would have likely won, because the non-discrimination language in the contract would have been considered neutral and generally applicable. In other words, without that technicality, they would have said, well, this isn't really a case of singling out one foster care agency. Without that exception in the contract, it would have been a neutrally applicable law applying to every foster care agency. Had that been the case, it would have met the standard that would have allowed the court to support the city of Philadelphia. Now that's important, and I know that's language you're probably not familiar with, but that's language that in fact is pervasive in American jurisprudence that disenfranchises and disadvantages religious freedom. So, keep that in mind. We're going to come back to that language. We're going to come back to that problem. All right, let's talk about this last case. So our final case here I want to talk about was decided on June 15th of 2020. It's the Bostock versus Clayton County case. How many of you have heard of that case? Anybody? Bostock? Okay. Well, just listen carefully. There's so much here, but I've got to, for the sake of time, just kind of really hit the high points. Tell you the results, the outcome of it. The Bostock case literally redefined the term sex. Sex in federal statutes and historical jurisprudence had always referred to biological sex, male and female. The Bostock decision in 2020 redefined the term sex. It weakened women's and girls' rights and protections under the law, and aligned with trends of culture with the misunderstanding of human nature rather than relying on historical statutory precedent. In a shift of seismic proportions, the court ruled in a 6-3 decision that federal law prohibiting employment discrimination based on sex, the term sex, makes it unlawful for an employer to fire or refuse to hire an individual for being gay or transgender. Now, for over 5 decades, the way the term sex had been used in federal law, for over 5 decades, it had meant biological sex, male and female, as created by God. Courts at every level, high level, low levels, had understood the term in that manner. But here, Justice Gorsuch, writing for the majority, deviates from that meaning, deviates from a literal meaning of the text, deviates from what the law's drafters in 1964 of the Civil Rights Act intended the term to refer to biological sex. Now he finds, in the ruling in 2020, the court rules that, in fact, today's cultural milieu that allow for homosexuality and transgenderism and these issues that deal with human nature to come into play in the understanding of that term and redefine the term sex to include sexual orientation and gender identity. Not all of the court saw it that way. Justice Alito said, well, there's only one word for what's taken place today in this decision, and that is legislation. Not that the court has followed or interpreted the law, but that the court, in fact, has now stepped out on the limb and, in fact, has made law, new law. Well, the implications of Bostock are huge. It raises these questions. Will faith-based institutions be required to hire gay or transgender employees even if it violates their understanding of the human person? As this decision plays out over time, Will the traditional definition of marriage come to include same-sex couples? Will it even be required that that be taught in our schools? Will doctors and nurses be required to perform sex reassignment surgeries, or lose their jobs, or be fined, or lose their licenses, even if doing so violates their religious conscience? It opens up all of those questions and the floodgates of litigation. Those are the implications of Bostock. Are there threats to religion and religious freedom in society? Yes. I'm not turning over every rock looking for them. In fact, that's just not my nature, to go and look for the problems. But are they there? These are cases clear as can be, that in fact the cultural influences of the day are finding their way into our courts' decisions. More is at stake here than claims of unlawful employment discrimination. Where unlawful employment discrimination exists, under the plain meaning of the Constitution and based on legal precedent, then listen, let's roll up our sleeves and fight it. Where we see examples of that kind of discrimination in society, regardless of who suffers from that discrimination, then let's fight it. It's contrary to law. It's contrary to human nature. Whether it's me, whether it's you, whether it's people we don't understand, whether it's someone that claims to be gay or transgender in society, those types of discrimination should not be permitted or embraced in society. Let's roll up our sleeves, let's get to work, and let's find the right legal mechanisms to protect against those discriminations. But while we do that, we must not be willing to redefine human nature as created in the image of God. These decisions move that direction. That is where this case intersects with religious freedom. And there we must stand. And the truth that we know about human nature and about conscience and how this impacts our relationship to each other and the truth of Scripture and orthodoxy in our societies. So we've looked at these laws, and now we're going to step into numbers 3, 4, and 5 on my list. We're going to step in to, we don't want to go there quite yet. Let me go past this. We're going to come back to that other slide. And so I want to look at numbers 3, 4, and 5 back from the beginning. And I think it would help us just to look back there quickly. Legislation, bills that are being considered in our Congress that would become federal law. So what we've just talked about are individual cases. They certainly impact how we live, how we relate. They shape our society. But even a step really beyond that, because that's the court, even the high court, the Supreme Court, is supposed to interpret the law, right? That's what was problematic in Bostock. Not just interpreting the meaning of a word, but actually changing it. Questionable. But what legislation does is actually makes the law that the lower courts and the Supreme Court then interpret and apply in society. So if in fact something becomes a federal law or a national law, then that applies to all people, all courts, every segment of society. So here we're going to look at legislative initiatives that are shaped by cultural influences, in fact, have embedded in them a false anthropology. Legislative initiatives that repress religious freedom and really create a new moral orthodoxy. And legislative initiatives that abolish defenses of religious freedom. Now you say, oh my goodness, how many bills are we going to look at? Legislative initiatives that do all that? One. Only one. That's all we need to look at. So one, I'm going to spare you the pain. Okay? We're not going to look at many. That's my job. We're going to look at only one. And in fact, if it passes in the United States Congress, and it has already passed the U.S. House of Representatives, it has been introduced into the U.S. Senate. There have been hearings on this bill in the Senate. If it passes, it in fact will encompass all of these things. So we're going to go back down to that slide. And we're going to talk about the Equality Act. Now you might say, David, well, that sounds really good. And I'm for it. Equality. Our Constitution, our country is founded on the premise that all men are created equal. And yours is as well. But don't let the name fool you. So that's what we're going to look at. And to do that, I need to have another slide presentation put up. Now, here I'm going to have to ask you one more time, work with me here because I'm actually going to show you the bill. Okay? So don't think, David, is this really relevant? Well, it is relevant. Because again, if this passes, this becomes the law of the United States of America. And I guarantee you, this type of legislation is already being considered in Europe. And if this passes, the likelihood of it becoming law in Europe and beyond goes even higher. So let's look at this bill. I want to now step from these cases in which you started to see, especially in Bostock, some early warning signs that some of these things could happen, the threats to culture, and now what's actually in this bill. So we're just going to look at some highlighted sections. I want you to note, again, the name of the bill, the Equality Act. The purpose of the bill to prohibit discrimination on the basis of sex, gender identity, and sexual orientation and for other purposes. Again, I want to be on the record that no person, individually or in community with any group, deserves to be discriminated against. No person. And I will stand to defend their rights against any form of discrimination. But let's understand all that this bill says. And so I want you to understand here, notice the focus here is similar to Bostock. It brings in the word sex, but now kind of this new understanding of sex is introduced. Gender identity, sexual orientation. So these are the findings of the bill. These are affirmations of what the writers of the bill are now proposing are true. Discrimination can occur on the basis of the sex or sexual orientation or gender identity, etc. here. So these concepts are now being considered to be introduced into national law. Oops, let's go back up. Here, specifying the language even further, lesbian, gay, bisexual, transgender, and queer, referred to as LGBTQ, people commonly experience discrimination in securing access to public accommodations. We're going to come back to this concept that is critical to understand in this bill about public accommodations, places that invite and provide services to the public. These are places of public accommodation. You'll see how important this is in that bill in just a moment. A few of those that are listed here that are included as places of public accommodation: healthcare facilities, shelters, that might include women's shelters. So battered women, women that have suffered abuse that go to women's shelters under this law, now considered a place of public accommodation. Adoption and foster care providers sound a little bit similar to Catholic social services. These are services provided that provide a public accommodation. So now there's a very clear tie back to this being that kind of place where there can be no form of distinction or discrimination. So when I say Fulton didn't quite go far enough, so now the door's opening back up in this national law. Notice the far-reaching claim there previously. This discrimination prevents full participation of LGBTQ people in society, disrupts the free flow of commerce. These are all affirmations. These are claims that the writers of the bill are kind of basing the bill on. They're proposing that all of these things are true. That's how bills are typically written. Many employers have already addressed these issues. Many places of public accommodation, are also recognizing these issues is basically what the bill says. Notice here how LGBTQ kind of tags on to women's rights. So it's a very subtle way in the U.S. that progressives or proponents of this bill are trying to advance the LGBTQ rights by tagging on to the successes of women's rights that have already been approved and embraced in American culture. And you'll also see in this bill, even more than that the LGBTQ rights are tied directly to our 1964 Civil Rights Act, which is based on non-discrimination for color. And so what the progressives are trying to do here is attach LGBTQ rights to other groups within society that have already been protected in national law. So you can see here the link to the 1964 Civil Rights Act. And so they're setting up the system of thought that rights for LGBTQ persons are the same as rights that have already been decided for women, rights that have already been decided related to race. Now, areas in which this bill addresses discrimination, employment, housing, again, public accommodations, programs and activities receiving federal financial assistance. So what they're setting up in this bill is that all of these areas, we want to change the law so that the same rights that women have, the same rights that cannot be discriminated on the basis of race, are equal for LGBTQ persons, is the point here. And in instances where there might be, if there's an instance of discrimination, that any place federal funding is permitted, then must completely endorse the rights of all LGBTQ persons. So, do schools receive federal funding? In many instances, they do. All right, let's keep going for just a moment. Notice here that the assertion is made that discrimination is based on sexual orientation includes discrimination based on an individual's actual or perceived physical status. So now, sex, as in Bostock, is no longer simply perceived as actual. It's also being explained here as a perceived trait. So in other words, we go back to human nature a little bit, don't we? Is human nature actually male and female, biologically affirmed by medicine and science, male and female as created by God, or is sex now either actual or just as legitimately whatever it's perceived to be? So there's a transition here in understanding of human nature. All right, so let's go on down through here. Notice how interesting that the proponents of this bill would tie it directly to the decision in Bostock, right? So they're using Bostock now to defend the premise for this bill. So this just kind of goes through a number of areas that the bill tries to protect. It points out that LGBTQ persons need additional protection. Let me just mention a few of those. Access to housing. The claims are that there's been access to housing has not been equally permitted. It's been denied in some instances. Access to fair credit in the U.S. or to serve on juries or the right to an impartial jury. Again, let me come back and say, where those are instances of discrimination, as a society, as a culture, we must defend against that kind of discrimination. In all of those areas, let's strengthen the enforcement mechanisms of law to do that. For every person. I'll be first in line to do it. But that is not what's underlying this bill. It's not the only thing underlying this bill. So that's what it's going through, though. Here we go to the child placing agencies refusing to serve same-sex couples. Now you can see how Bostock finds its way back in again to this bill. Now, up here, courts consistently have found that the government has a compelling interest in preventing and remedying discrimination. So let's stop there just for a moment. Now you've got to really buckle your seatbelts on this one, okay? Back on Fulton, you remember where I said that it turned on a technicality? And if it wasn't for that technicality, then the law would have been interpreted to be neutral or generally applicable, because there's no technicality here. And the fact that the city of Philadelphia is saying we cannot allow that form of discrimination, and every foster care agency, regardless of whether it's faith-based, a Catholic social services, or any other, we're going to apply non-discrimination law against same-sex couples. That law would be evenly applied, generally applicable across all foster care agencies. But it was that technicality in Fulton that allowed the Supreme Court to rule otherwise, in favor of religious freedom, but based on a technicality, right? Because the opposite, another way of interpreting the law in America that finds its way into the Strasbourg court as well, is what's called high scrutiny. And I maintain that in the U.S., with regard to fundamental freedoms, fundamental rights, including religious freedom, that we must return to that higher level of judicial review. And you begin in that instance, it places the burden on the state. Follow with me, 2 minutes. You can get this, 2 minutes. We'll move on, step back, get a breath of fresh air, okay? Here we talk about compelling interest. The higher level of judicial review shifts the burden to the state. And in fact, in an instance like Fulton, without that technicality, then the state has to say, well, there's a compelling interest why we would not let a faith-based institution carry on a service that it has for 50 years, maintaining its integrity, its faith commitment to marriage as a sacred bond between man and woman is, in fact, what Catholic Social Services base their defense on. That claim, that faith claim, that truth within their faith. And the government would have to say, well, there's a bigger interest, a bigger compelling interest. We can't allow the church or the Catholic Social Services to continue that way. And if the government can then find a compelling interest, then high scrutiny, strict scrutiny, requires that a decision would have to be narrowly tailored to achieve that compelling purpose. And that narrowly tailored decision must be the least restrictive means to achieve the purpose. So you can see with a compelling interest, a level of strict scrutiny review, the government really has a burden to identify compelling interest and then to make a decision that's very narrowly tailored to that situation. And in that situation, the least restrictive means of accomplishing the government's purpose must be applied. It's almost the opposite of the neutral and generally applicable law. So it's looking at each instance, for example, and saying that, well, religion wins. Religion has been doing this for 50 years. And there's an interest in society to protecting those services and to protecting religion and the place that it has in society. That's strict scrutiny. Okay? Now, what the writers of this bill are trying to do is trying to say, well, that's really what the government is doing, or we're proposing that they do in this bill. And you kind of see how that plays out here. Why is that the case? Well, it's because of Bostock, basically. So, here we get to that language, see? So, as with all prohibitions on individual invidious discrimination, the Act furthers the government's compelling interest in the least restrictive way. So, they're trying to set up this higher scrutiny as a reason to support LGBTQ rights in this bill. It's an interesting approach that's being taken. So I want to scurry through this now. Public accommodations, I want to come back there, show you that this is one place that it is particularly, potentially injurious to the church. The institutions of faith. So I guess we'll have to catch this last paragraph here. It's not clicking up right. But notice here, with regard to public accommodations, here that understanding sex in terms of sexual orientation and gender identity is very specific. And in this part of the 1964 Civil Rights Act, what they do is they insert stadiums or other places of public accommodation. Follow with me up here. The top, other place or establishment that provides exhibition, entertainment, recreation, exercise, amusement, public gathering or public display. What they're doing here is they're giving you a list of services and of places of public accommodation that would fall under this law. All right, so here's the point of application. My church in the United States provides, wedding for its members. There are some churches in the U.S. that would say, well, we're willing to perform the wedding ceremony for another couple. They need to visit with the pastor. They need to come in and have meetings with the pastor, show that they're people of faith. They may not be members of this church, but we would open the doors, and after meeting with the pastor could decide, well, yes, we'll perform that ceremony. Okay? Public schools in the United States are places of public accommodation. You move into the community, you live within certain boundaries, that's where your child's going to school. Elementary school here, middle school there, high school there. It's a place of public accommodation. Some churches in the United States, try to be open to their community. And, maybe on Wednesday at noon, they have a yoga class for, people from the community that are home on Wednesdays at noon, and they come and they have lunch. It's open to the community. It's a way for the church to get to know people in the community, to have outreach to them. Some churches might offer a class on financial health. And it's not just open to the members, it's open to people of the community. So once you open your doors to the community or provide any service to the community, you become a place of public accommodation. Once you become a place of public accommodation, you would fall under the prescriptions of this law, and you would be required to adhere to it. Which means, in the case of a church and a minister being open and performing for wedding ceremonies for a couple that comes and meets with him, the same-sex couple comes in the doors of that church under the provisions of this law, that minister and that church is required to perform that ceremony. Even though the fact that a same-sex marriage might be in disagreement with the traditional understanding, as in Fulton it is expressed, that marriage is a sacred bond between a man and a woman. But they'd be required under this law. Public schools, for example, bathrooms become a problem because now you have a female student who claims to be a male student, and they want to use the male bathroom. They want to play men's sports. And so they're now, the issue is under this law, they would be provided access to those locker rooms. A male who says that they are transgender and recognize themselves as female, now in a place of public accommodation, they have open access to the women's bathrooms. Okay? A church. Some churches, one of the churches I've been to in Texas, they kind of have a coffee shop. It's open to the community. And anyone can come in and affiliate with the church in that way. And so you have a cascade of issues now in society under this bill. And it all goes back to these two competing views of reality where I began. A reality that is based in anthropology, that affirms human nature and human dignity. It's created by God. Understanding truth is to be found in not just ourselves, but truth, in fact, ultimate truth is to be found in a reality greater than ourselves. And yet this other reality, this super kind of individualism today, exalts the self to the point that the self becomes the determiner of truth. So this is where we're at with this bill. And we'll go down through here real quick. Here we have public education. I just mentioned that. Employment in the federal government would be protected. I mean, just every aspect of society. We have definitions here in the bill. Gender identity, what does that mean? The term gender identity means the gender-related identity, gender-related, understand, appearance, mannerisms, or other gender-related characteristics of an individual, regardless of the individual's designated sex at birth. That is no longer what matters. This is the ontology of this ideology, of this view. This is the human nature. Here the term sex, you can see, goes back to Bostock in a sense. Sex is really a stereotype. Under C, sexual orientation and gender identity, sex characteristics, including intersex traits. The term sexual orientation means homosexuality, heterosexuality, etc. So it becomes very clear in the definitions. And we're just about through with this. Finally, the thing I wanted to point out. You remember I spoke about the Religious Freedom Restoration Act? Way back on Fulton. I just was way back actually at the beginning on our slide deck. How legislative initiatives would repress religious freedom, was number 5, would repress religious freedom by abolishing defenses of religious freedom. That's what it stated. And then I had in parentheses RFRA, the Religious Freedom Restoration Act. The Religious Freedom Restoration Act was enacted in 1993 in the U.S. by unanimous vote. And it affirms judicial review on the higher level of strict scrutiny. So the burden is on the state. Remember that? There's another one of our touch points just 10 minutes ago. But the Religious Freedom Restoration Act was enacted in the U.S. to go back to our First Amendment, where the First Amendment affirms that there will be no prohibition against the free exercise of religion in society. It places the freedom to believe, the freedom to embrace religion, the freedom to express it. It places that at the center of our life and culture in the United States, and how important it is to protect that. This act abolishes the Religious Freedom Restoration Act in its application to these LGBTQ provisions. Shall not provide a claim concerning or a defense to a claim under this title. So I'll stop there on this bill. That's enough legislation. You've had all you probably need the rest of your life. This is the kind of thing that I've done for years as I work with Congress and either in helping draft at times legislation or in a case like this, fighting against legislation that would bring harm to religion and religious freedom and its place in society and the freedoms that you and I enjoy to believe in God, to go to church, and to practice our faith. Now again, that bill has already passed the House of Representatives. It is approximately 10 votes shy of passing the Senate. That's where it stands. about 10 votes shy. I'm not the guy that's doom and gloom. I'm the guy that's Mr. Optimistic, honestly. But if this kind of law becomes inculcated into society and culture, it will affect everything about our lives. It will repress religion, and it will bring great harm to religious freedom here in America, throughout Europe, and throughout the world. And it will impact our ability as a nation to reach out to places around the globe where there is persecution of the innocent, where there is persecution of ethnic and religious minorities. It will bring great harm and inability for us to do that as a society. You say, does this matter? I mean, because it sounds pretty technical, it sounds pretty academic. Sounds like, well, y'all discuss that, in the classrooms, you discuss that in your academic world, you discuss that at a think tank like RFI. Does this matter? Absolutely, it matters. It matters on the ground in northern Iraq. It matters with Rohingya Muslims who've been slaughtered and persecuted. It matters all around the world. So that's why you find me and many others digging our heels in on something like this, which compromises not just my ability to walk into the doors of a church and to worship, but in fact it compromises my entire ideology, my worldview as a Christian, because it attacks human nature. It redefines human nature. And by so doing that, threatens religion and religious freedom for me and for the ethnic and religious minorities around the world. But I want to draw a few conclusions first. Just take a few minutes. What does this mean? How do we respond to this? Again, this is where we are in culture today. And so I want to make a few comments on how do we appropriately respond. And again, I want to come back to say that, every individual has intrinsic worthiness, because they are created in God's image. And so I want to say first that, despite our conversation and our awareness of these real world issues that are in fact are threats to religion and the place of religious freedom in society, we want to rediscover how we treat one another, and in every instance without any form of discrimination. And we want to learn, again, how to have conversations in kindness. I'm reminded that, our Lord hung out with the tax collectors and sinners. And, it's good for me that he did. So, perhaps one of the strongest responses that we can have is to learn how to talk through our differences and rediscover Christ's compassion. At the same time, we do recognize that the Equality Act and the principles that it proposes to support in society is in fact a direct affront to religious teaching, religious truth. It is a direct threat to religious free exercise. It represents, in my opinion, at least one of the most serious threats of the day to the free exercise of religion in American society, and I think beyond that. A few practical implications of that is it exposes faith-based institutions to ruinous lawsuits, threatens women's rights and girls' rights and their safety. It may mandate the performance of medical procedures and providing products, medical products, that would violate one's conscience, religious conscience. It redefines faith-based institutions in many instances as places of accommodation, public accommodation. And we see the ramifications of that. It creates unsafe environments for our children. And it abolishes the defenses of the Religious Freedom Restoration Act under claims that are brought under the Equality Act. So, third, we need to understand that the Equality Act and what it teaches about men and women is built on false views of human nature and human sexuality. That's where we began this conversation. Fourth, we understand that sexual orientation and gender identity ideology, and it is an ideology. It's not based in medical science. It's not based in ontology. Sexual orientation and gender identity is an ideology. It is a worldview, an ideology that becomes part of a worldview. And it represses religion and drives religious freedom from public life. But religious freedom is an inalienable human right. It's not created by our courts, created by men or women. It's bestowed upon us by our Creator. An inalienable human right, as understood by the American founders and even leaders throughout the history of Poland. If I read the First Amendment correctly, and we'll look at the text of that in one of our later sessions, the framers of the First Amendment understood religion and religious freedom as a core component of public life, a core component of democracy, a free and stable society that would help create a virtuous citizenry and contribute to the flourishing of individuals in society, whether they embrace matters of faith or whether they don't. Fifth, and I only have 6 kind of conclusions here. Fifth, we do in fact need to restore the highest standard of judicial review. I've said enough about that in the few moments we spent on it. But in fact, it should be the standard for our courts. Finally, it's incumbent upon all of us, with the opportunities we have, to make God relevant again through education. In the beginning, when I talked about the 2 competing accounts of reality, in one that is open to this new way of thinking about human nature, and I think subtly redefining conscience, and that one, for whatever reason there may be, it seems as though God is not relevant. And the truths of the faith are not as relevant. And perhaps that says something about us as much as it does other people in the way that we teach and we communicate and we deliver and represent our faith in community. So I challenge you within an educational setting. That's where we began. Education is the incubator of culture. Make God relevant, again, through education.